I think we might get underway now. I'd like to start by acknowledging the traditional custodians of the land, the Ngunnawal people, and pay my respects to elders past, present, and emerging. Welcome to the third online conversation on racism in Australia, organised by Blue Star Intercultural and the Australian Centre for Christianity and Culture. My name is Noor Haider. I'm a political reporter with the ABC, and I'm excited to be facilitating today's conversation on racism and the law in partnership with Legal Aid ACT. In the context of the recent Black Lives Matter protests, we'll explore the experience of Indigenous Australians in the Australian legal system and pose the question, how can we collectively dismantle systemic racism in the law? Before I begin, I'd like to ask Julie to deliver an acknowledgement of country.
Thanks, Nora. I'd like to acknowledge the traditional owners of the land that we meet on today, the Ngunnawal Ngambri peoples, and pay my respects to both elders past and present. I'd also like to acknowledge Shane and Desmond, so thank you.
Thank you, Julie. Now, before we move on to today's conversation, I will introduce our panellists. Shane Rattenbury is the ACT Greens leader and member for Kurrajong. He currently holds several ministerial positions, including Minister for Corrections and Justice Health. Professor Desmond Manderson is the Director of the Centre of Law, Arts and Humanities at the Australian National University. He researches interdisciplinary connections in English, literature, philosophy, art, history, law and legal theory. And finally, Julie Tongs is a Wiradjuri woman and has been the CEO of Wenunga Aboriginal Health and Community Services for more than 30 years experience working in Aboriginal and Torres Strait Islander affairs, including advising, formulating, implementing and evaluating public health initiatives. For those of you joining us today for this conversation, we will be taking questions at the end of this session. If you'd like to ask any questions, you can share them through the YouTube chat function or the Zoom function on the Zoom chat function. We will try and get to them at the end of this session. To begin our conversation, I will like to start with you, Desmond, to sort of set the scene for where we are today. You've explored colonial histories in different countries around the world and recently convened a course at ANU called Colonialism and the Rule of Law. Can you tell us a little bit about Australia's history of colonisation, interactions with First Nations people, and I guess how those experiences have shaped where we are today? Well,
that's a really big question, and
it is a loaded question.
I suspect a lot of people have much more knowledge than I am. Obviously, frontier violence was a fact of life in Australia for well over the first 100 years of settlement. And it was often, there was often a culture of impunity in Australia in relation to settler violence, where, there was just no sort of sense of accountability or responsibility for those acts of violence, including massacres that happened all over Australia. And it was often kind of understanding, some people would argue that it's often the things that we don't talk about, the hidden truths or the secrets that bind us together as a community, create a shared kind of sense of guilt or shame. And I think that there's certainly parts of the Australian legal system and Australian culture that are bound together around those secret stories. Of course, they're increasing, not so secret, but that was certainly, part of the ways in which colonial frontier violence took place for a long time. I think of two things. Firstly, I think about the first time that I learned the law in Australia many years ago when I first did a law degree, and in just about the first class that I ever took on constitutional law, basis of constitutionality in Australia, our lecturer said that Australia had British law from that Captain Cook took possession. From that moment on, the British common law was the law of Australia. And at that time, again, this is quite many years ago. At that time, nobody in that class, I think, thought to question that statement. And yet, when you think about it, It can't be true. It's a complete myth, that statement, because they're obviously the Australian, the settlers in Captain Cook's time and Captain Phillip's time had didn't even know the extent of Australia. They hadn't even mapped the whole place. They made this statement in complete ignorance of the nature of the continent, and obviously there were many Aboriginal communities that didn't even see a white person for 100, even 150 years after that. So the statement that British law was the law of Australia from the moment that Captain Cook claimed possession of it in 1770 can only be a myth. And yet it's a very powerful myth, that kind of organised and, you know, terra nullius, the idea of the empty land, is a classic example of that, of a kind of a myth that had no basis in fact, and yet which structured interactions between European and Indigenous people for hundreds of years. So when British settlers and British convicts came to Australia in the late 18th century, they brought with them guns and they brought with them germs, but they also brought with them ideas, concepts and myths. And it was out of those ideas, concepts and myths that the history of settlement, the history of the violence of that settlement, and the history of the denial of the violence of that settlement took shape.
And Desmond, how that continued to permeate through our modern, into modern times and into our modern legal structures and legal systems?
Yeah, I mean, I think that's exactly the power of a myth, is that it's not, you can't, it's very recalcitrant to history. It doesn't just get changed. So those stories about the peaceableness of common law, about the legitimacy of the foundation of law, about the kind of colourblind legal system, all of those kinds of ideas continue to operate to deny Aboriginal people proper access, proper recognition of their own legal system and so on.
Can you give us some practical examples of what you're referring to?
You know, I mean, an example I was going to use, again, this very high level of abstraction, but it's actually the thing about Australian law and settler colonialism that has most struck me this year, of all of the things that I've read this year. And that was a little article by a chap called Lorenzo Veracini in Melbourne. And he says there's two types of colonialism. And it's a great metaphor for 2020. There's viral colonialism. Colonialism is like a virus. What does a virus do? It goes and invades other places and it takes them over. It appropriates their resources and it uses them. And many kinds of colonialism around the world were like that. They were viral. They appropriated people and resources and used them, you know, as slave societies did, or as the British in India or the British in Africa. And then he said there's another kind of colonialism, and it's not viral, it's bacterial. And bacterial colonialism is not interested in appropriating people. What it wants, and this is a characteristic of a bacteria, it doesn't take over other kinds of cells. It simply appropriates space. And it just wants space to grow and space to expand. And the bacterial kind of logic, the logic of the bacteria is that other organisms are just nuisances to be ignored or eradicated so that spaces can be fully filled. And that was settler colonialism, was bacterial colonialism that saw Indigenous people as obstacles to the growth of the settler colonies. And in fact, the whole logic of terra nullius has sort of come out of that that kind of, you know, way of thinking about it. And if you think about those two ways of thinking about relations between colonizers and colonized peoples, the viral and the bacterial, I think you appreciate both the different ways in which they are insidious exercises of power, and their differences as well as their similarities.
Shane, I might draw you into this conversation. The recent Black Lives Matter protests resonated right around the world, particularly in Australia. We even saw protests here in the ACT. Why do you think it is that so many Australians identified with that incident where we saw a police officer kill an unarmed black man in the United States?
I think the simple demonstration of the power imbalance laid bare for people the abuse of power. It was such a horrific act where a man was clearly prone. He was begging for his life, and yet there was a lack of compassion shown by the police officers. I think just really cut through to people. And whilst his death was sadly only one of many deaths in the US at the hands of police, there was something very poignant about the image that really spoke to people. I think here in Australia, I found the reaction very interesting in the sense that people were looking to the US saying that's outrageous. And yet there hasn't been the same focus on the loss of Black lives in Australia in the justice system broadly. And so it brought that into focus in a way that there probably hasn't been in Australia. We, of course, saw the incident in Redfern at the same time with a New South Wales police officer, and I think that probably really brought it home to Australians that this happens here as well.
Shane, a lot of people at the time commented that the Black Lives Matter protests here were highlighting the injustices faced by Indigenous Australians. Why isn't there already a widespread recognition of those injustices, perhaps like we see in the United States? Why do you think that Australia, or it seems at least that in Australia, there are people who are, I guess, who haven't realised how the nature of the things that you've spoken about, that Indigenous deaths in custody occur here, and the extraordinary sort of discrepancy in incarceration rates in Australia as well? Why isn't there a recognition within the community about that, or is there, and perhaps action isn't just moving fast enough?
I think there's varied recognition in the community, Nora. It's a really good question. I think a lot of Australians simply don't see the issues. They probably don't get the mainstream media coverage, or when they do, it's very brief. There are people in Australia who are working very hard on these issues and who are very aware of it, but I think it is masked. It's not widely covered. And for many Australians, it doesn't directly impact on their lives, and so they perhaps just don't focus on it.
Julie, I'd like to
I guess if I can just come in on that just for a second and say, I think partly the kind of the ways in which our legal system still takes such an abstract approach to thinking about legal problems. And that allows them to sort of consistently ignore facts that get in the way of those kind of formal languages.
Can you give us an example?
If you look at, sorry?
An example. Can you give us an
Yeah,
example?
sure. So if you look at, like if you think about Mabo's case, which marked a really important step forwards in many ways in recognising that the stories we'd told about terra nullius could no longer survive the reality, which was nothing to do with that. But one of the things that came out of Mabo's case was the stolen generations. Those were people who were excluded from claiming native title because they had been removed from their families and they had lost the kind of claim that Mabo would have recognised. Those Aboriginal people then went to the High Court and wanted recognition that the Australian government had been guilty of genocide in taking them away from their family. And when they went to the High Court said, we are not even going to hear evidence of genocide. We are not interested in the facts of your stories. We are not interested in what particular ministry did. We are only interested in the abstract words of the law. And what they said is that those laws should be exercised for the benefit and care of Aboriginal people. So they just looked at the words and they said, nothing there about genocide. If nasty things happened, it wasn't the fault of the law. It wasn't the fault of the government. It was some individual officials that did the wrong thing. They failed to take any account of actual social history or the social context that gave those words meaning. They refused to look at the actual meaning of words in a particular context, and the result was that the plaintiffs failed.
Julia, I'd like to bring you into this. How much of this is, or the problems that we see now are because or exacerbated because of the structures, the legal structures that we have in place, and the fact that injustices of the past to an extent have not been acknowledged in this country?
Absolutely, and they haven't been acknowledged. And for me, Black Lives Matter 365 days a year, not when, people take the streets to protest. I can't understand why, they say, Canberra's a progressive place and, it's a great place to live. Well, it might be a great place to live for a lot of people, but there's a lot of disadvantaged, vulnerable people in this community, and particularly First Nations people, that don't get a fair go. And because of that historical trauma when they were growing up, and people say, well, you know, he's a perpetrator or he's this or that. Well, a lot of these fellas, they were victims before they were perpetrators. And if you need to be able to sit and listen to them, listen to the story of their families, and to understand and stop judging people. And I know that the law, you know, the police pick people up, but a lot of these people are targeted, and then their kids become targeted. You've got child protection. You know, we talk about kids being removed. Well, we've got more kids being removed now than what we did from the stolen generation. We've got more Aboriginal people in jail than in university. You know, there's such a...
Shane, you're the Minister for Corrections here in the ACT. What is the government here doing to I guess, address the overrepresentation of Indigenous Australians in custody?
Yeah. No, the approach we've taken is to work on the theory that the best way to keep Aboriginal and Torres Strait Islander people, I guess, engaged in the community is to make sure they don't go to jail in the first place, to make sure they don't end up in the criminal justice system. And so we've put a real emphasis on justice reinvestment. The idea that we should spend our money up front rather than spending it on building ever bigger jails. And the very practical example of that was about 3 years ago, our jail was full and we were given a feasibility study to say we should add 200 more beds. And instead we took an explicit decision not to spend the money expanding the jail, but instead put the money into building communities, not prisons, is what we tagged it. If we had expanded the jail, I can guarantee you simply more Aboriginal people would have gone into custody. They would have gone to jail. And so in capping the size of the jail, that is a starting point. Now, what flows from that is lots of very practical things we need to do, but that's the big picture approach we're trying to take.
Julie, what's your response to that? Are those the sort of things you'd like to see happening? What more can not just the ACT governments right around the country, successive Closing the Gap reports have shown that there is little progress being made, not just around justice issues, but a plethora of other issues.
Absolutely. And, you know, I totally agree. You know, what's been done in the past isn't working. We need a new way of doing business. And, you know, governments, politicians, people need to start listening to the people on the ground. You know, instead of you send in the researchers, you do the recommendations, you send it up to government, nothing ever happens. Look at the Royal Commission into Aboriginal Deaths in Custody, the Bringing Them Home report. How many more reports, how many more recommendations do we need before we're going to change anything? And yes, and Woononga's part of the justice reinvestment strategy, and we've got 14 families that we're working with, but we're not talking about generic families. We're talking about, you know, there's more than just, you know, mum and dad and 2 kids. There's, you know, there can be 20 or 30 people that are closely connected in that family, you know, with the extended family or even the immediate family. So that's bigger than one person. And for me, you know, we do cradle to the grave healthcare and everything in between. We talk about close the gap. Well, Woononga is the gap filler, you know, because we don't have an Aboriginal child care agency. We don't have an Aboriginal Justice Centre. We've got a rehab, or we had a rehab built out at the Ngunnawal Bush Hilling Farm. And, you know, nobody's going there for rehabilitation. We need our own Aboriginal specific services, you know, and you'd think that in 2020 in the ACT that my people would be able to access mainstream services, but it's, you know, the systemic racism and the racism towards us as a service, and to me personally sitting in the room with some of these people, is just in your face. And I can say to people, I'm not meeting with you again. But when
Julie, how do we change that?
Well, you know, the thing is that people need to start to show some respect and learn about the history and listen. You know, just because you worked overseas and, you know, in Canada or somewhere like that, doesn't mean, and, you know, there are some similarities, but at the end of the day, we're the first Australians, you know, and don't come in here telling us how that we should do our business. because we know how to do our business. People need to listen to us, trust us, and let us get on with it.
That you mentioned earlier that there needs to be an emphasis on listening to those working in frontline services, working on the ground. How disappointing is it to you that something like a voice to Parliament, it doesn't seem to be happening? The Uluru Statement from the Heart has sort of gone by the wayside. And Desmond, I'd like to draw you into this conversation when you talk about myths, or the sort of proliferation of myths in the community. How significant are those big, I guess, moments in a country's history to sort of shifting or breaking those myths?
I mean, I think on that point, you know, absolutely. I think these myths and stories that we tell ourselves about the kind of law we have and the kind of history we've had and the relations we've had, you know, they do perpetuate in really powerful ways cycles of trauma on one hand and cycles of forgetting on the other, right? And the nature of trauma is the impossibility of forgetting, the impossibility of putting something into the past, like a wound that doesn't heal and just continually gets hurt and re-hurt. Forgetting is like the opposite of that. And, you know, like that's what you see, that the myths about, you know, about Australia and about the Anzacs and all of that sort of thing get told and retold. And on the other hand, the stories of Aboriginal life and injustices to Aboriginal people are constantly being forgotten, right? They're constantly, and this is why, as Julie said, there are these, how many reports? Well, the answer is, it's because we seem to continually forget the reports. You know, like we have the report and then 3 years later we have another report and everybody is shocked and horrified and it's like, goodness, who knew? It's like, well, obviously Aboriginal people certainly knew. So I think that it's the trauma on the one hand and the forgetting on the other hand, that the myths constantly revive and recycle. And so breaking through those myths or responding to them differently, telling different stories, and this is where the Statement of the Heart, I think, becomes very important, are really important ways of breaking that cycle.
How important is, I guess, education in schools, in our education system, in changing that? Is that where we need to be starting to prevent the racism seeping into structures and institutions elsewhere?
Well, I mean, I think, you know, one, yes, absolutely. Two, I'm always slightly hesitant about people who say, well, the answer is education, you know, because education can just perpetuate myths just as much. So it's a particular kind of education that we are all responsible for, not just for schools. But I certainly think, you know, there is more that we can and should do in schools. I mean, I think, you know, I would like kids in ACT primary schools to learn an Aboriginal language. I think that would be a really powerful way of engaging, you know, with Aboriginal cultural communities.
Shane, is that something you think that could be done?
You know, and the way kids are being taught at school today is a world of difference from when I went through school. I'm revealing my age a little bit here, but, you know, I was taught no Aboriginal history as a student, none at all. It's taken my adult life to learn about things like the Frontier Wars or the personal interactions. You know, we recently in the ACT Assembly changed so that we open the Parliament each day in Ngunnawal language. The Speaker has learnt an introduction, but in talking to the elders who came to speak to us about that, you know, they spoke about the fact that when they lived on the mission, they were not allowed to speak their own language. That's in, you know, within the last 70 or 80 years that happened. And they were immensely proud to see it being spoken in the Parliament, but I don't think most people in Canberra would know that. And so it's hard to comprehend the magnitude of the loss and the disconnection if you've not heard some of those stories or known what happened in Australia's past.
Shane, there are already some structures in place in the ACT designed to respond to the legal needs of Aboriginal and Torres Strait Islander people, such as the Galambini Court and the Warrumbul Circle Sentencing Court. Why is there a need for these specialised courts?
Well, the Jalambani Court is for adults and the Warrumbul is for minors. These are specially designed to try and take a cultural approach to justice. The magistrates sit with members of the Aboriginal and Torres Strait Islander community, elders, and they take a more restorative approach to justice. So instead of the magistrate just sitting there handing out the law, as Desmond spoke about it. It actually seeks to bring a cultural component. I guess it really highlights two things. One is the elders will inform the magistrate some of the context, the trauma, the history of the person appearing before the court, but also they're very clear in giving their cultural feedback to the young person or the adults, and as the case may be, that the criminal behaviour is not acceptable in the community. And so it's certainly not a soft option. I have sat in some of those sessions and the elders dish out some pretty hard truths to the people appearing before the court, but it takes a much more culturally sensitive approach to justice.
Julie, what's your response to that? How effective or ineffective are these methods, and how better can they be how best can our courts deal with these issues? And should there be separate court processes, or should the courts that we currently have deal with these things in the first instance in culturally sensitive ways?
Well, I think that, depends where you are in the country. And, like I've been involved in two inquests over the last couple of years, one in Canberra with the death of Stephen Freeman in custody, and the other one was with Jonathan Hogan, who died in custody in Junee Jail. And there was such a stark difference between the way that the court was held in New South Wales compared to what happened here in the ACT. So, I find it really difficult to understand why there's such a difference. And it is about attitude, and racism is alive and well in this place. And, I think that if you look different, you don't dress a particular way, you don't, speak a particular way, then you're going to be judged. And this is what happens all the time. It's not just about the colour of the skin, but it's in your face. These families, they've got this real sense of helplessness and hopelessness. Even out in the jail, I see them fellas at their worst in the community, when they're off their faces and they're coming here for help, and we're trying to help them and support them, but we're limited in what we can do. But then I know them when they're not on anything. And, they are the kindest, gentlest, caring people that you could ever know. And they're so respectful. But, if you treat somebody like a dog, you're going to start acting like a dog.
So, Julie, what needs to happen?
What needs to happen is that, stop, targeting these fellas. When they're out, all they get is targeted, by the police. That why don't they pick them up when they've breached parole instead of watching them, letting them go until they do serious crime, and then they bring them before the court again? The whole system needs to be tipped on its head and given a good shake. Because
Shane, what's your response?
Sorry.
Look, I agree with Julie, and Noor, you asked about those two particular courts, and I think they play an important role. But the more important part is that we actually go back and address some of the more fundamental issues, the social determinants of people's lives. And so that's where we're doing things like creating a justice housing portfolio here in the ACT, so that people can get bail and they've got somewhere to go, or they can get parole, so they've actually got accommodation to come out to. We've got a bail support program, which is designed to make sure so many Aboriginal people in particular get further into the justice system through what are called justice procedure offences, which is essentially failing to show up for your bail appointment or not following a bail condition properly. And we need to get away from people getting in trouble for those sorts of things. So the program that Julie mentioned earlier with the 14 families, that's a justice reinvestment initiative, where the idea is that Woononga is the lead agency. They know their families really well, and it's about working with them on a daily basis. And it's designed to keep people out of justice systems, but it actually does a whole lot of other things. And Julie can talk more about this, but the families that are being supported, we've seen improved rates of children going to school. We've seen improved rates of people engaging with healthcare. All of these other sort of things that go a long way to determining people having a successful life and not being involved in criminal matters.
Julie?
Yeah, the thing is that, like, we've taken on that program. We are doing some work, but it is difficult with housing, you know, having appropriate housing, you know, relationships break down, there's family breakdown while somebody's incarcerated. You can't keep putting people into vulnerable positions. You know, some of these places where people are getting bailed to, they shouldn't be bailed to these environments. We need to have proper bail houses. They need to be supported 24/7. A lot of these fellas don't know how to live on the outside. But the thing is for me too, and the most concerning thing is that often mob that have done petty crime in the past are coming out and their offences are becoming more and more violent because they're being locked up with people that are more violent. They're getting caught up in gangs. They're getting caught up in all sorts of things in jail. And then they're coming out here and they're reoffending, but it's much more violent than the time before. So, and you see it all the time. And, you know, I feel really, really helpless sometimes and so do my staff. But at the end of the day, they're our people and we'll do whatever we can to support them.
Shane, are the different methods that you've spoken about, is there any sign that they're actually going some way to reduce recidivism?
I think so. Well, we are seeing the early wins from it. A number of these programs we've invested in have seen a reduction in crime. We've got some place-based projects around some of the public housing areas in the ACT, and we've seen 50% reduction in crime through putting support agencies in. I spoke earlier about the program Julie's leading through Wurrungi. It's called Yarrawi Bamir, which is Ngunnawal for Walk Tall. We've seen good outcomes there. We're trying to build up a couple of other Aboriginal-led organisations in the ACT because I think having people who run the organisations being Aboriginal gives them much greater credibility with their own community, rather than simply the government or corrective services or the police running these programs. I think it's really important that we empower the Indigenous-led organisations.
I do have a question here from someone who's watching. I'll read it out. Does the notion of, quote, abuse seeds abuse apply here? So let me just scan through this before I read it out. Can people who have experienced abuse be held responsible? As a nation, would a recognition be held responsible for the future crimes that they might commit? And as a nation, would a recognition of our First Nations in the Constitution go a long way in righting the wrongs of the past? Julie, would you like to start there?
Well, that's where it all starts, isn't it, with the Constitution? Until there is constitutional recognition, people can, hide behind a broken system. And if you've got a broken constitution, well, the thing is that we all live and die by our constitutions as an Aboriginal community-controlled health organisation, as a director of NACCHO, the National Peak Body, but also, we should have a national constitution that recognises us as First Nations people.
Desmond?
Well, I absolutely. I think it's important, but obviously it's not enough. And even when we were talking about recognition in the Constitution, the voice to Parliament was something more than simply recognition. It was something which would actually have some substantive effect. And I think we have to think more about substantive as well as the symbolic gesture there. And I think we have to think about understanding much better the contexts in which offending and ongoing trauma sort of manifests itself. So, just to give you a story about that, if you look at the Northern Territory intervention, all of the laws that changed there, and someone did a really great study, Talia Anthony did a really great study of what had happened to law and crime in the Northern Territory after the Northern Territory intervention. So prosecutions for things like domestic violence hardly moved. Prosecutions for child abuse, virtually none. Prosecutions for those sorts of things didn't change at all, but there was an enormous spike in some area of offences. The area of offences where there was a huge increase was driving offences. It was people being prosecuted for driving without a licence. and being uninsured while driving a car. Why? Because there were policemen stationed in those communities. They're sitting around on the edge of communities. They want to get their prosecution numbers up, and Aboriginal people are driving off to maybe, events that may be 100 miles away with other members of their family, and they're being arrested for something that's got nothing to do with the intervention. Why are they driving without a license? Well, you could, where could they get the license from? How can they get to Alice Springs or Darwin? Where will they get lessons from? How could they afford the lessons? There are all of these contextual issues that start to make sense of why Aboriginal people in the Northern Territory might be driving around without a license, and why the policemen might suddenly be prosecuting them at ridiculous rates. And so understanding the deeper story that goes around this kind of statistical anomaly helps you see the ingrained patterns of lack of access, discrimination, lack of equity that are concealed behind a kind of an abstract idea like, prosecuting Aboriginal people for offences.
That sort of brings me on to another question that's been sent in. What would our speakers like to include in a police training program so the police deal more appropriately with their interactions with First Nation people to avoid deaths in custody? Julie, I'll start with you.
Well, I think that any training package, it needs to be delivered by Aboriginal people, and it needs to be embedded in their education. They need to actually know and work and understand Aboriginal people. They need to get involved in community initiatives. But, no amount of education or a textbook's going to change the way that people think and act. And I know that, when Justine Saunders was the chief police officer here in the ACT, there was a real missed opportunity when I took her out to the jail, to AMC, to meet some, and she'd resigned and was going to Border Force, and I actually did take her out there. She actually apologised to those men, but the shameful part of that was that they only brought four Aboriginal men down to meet her, and she apologised for the treatment that those men had the way that Aboriginal people have been treated by the police over the years. Now, all of them men and women out in that place should have heard that. But, this is the thing. You start to do good and you get pushed back. And then, corrections officers and mainstream services can't do what we can do as an Aboriginal health service or an Aboriginal community controlled service. People just don't, them fellas out there just don't trust them. They'll tell them what they want them to know, but they're not going to tell them everything.
Shane, is training the issue here, both with police or if we're talking about corrective services? Can training improve the sort of situations that we're seeing arise in a police setting, in arrests, but also once people are incarcerated?
No doubt it can. Or when it comes to things like arrests, I think there's a lot about how the law is defined. If you take something like anti-consorting laws, which has been debated heavily here in the ACT, what we've seen in New South Wales is they were set up to arrest bikies, but they end up being heavily applied to Aboriginal and Torres Strait Islander people. So getting the law right in the first place is incredibly important, but the training is very important. And I take Julie's point on board, and it goes back to the earlier conversation about education. If you have not met an Aboriginal person or spent time with them or seen some of the lived experience, it's very hard to then have either the empathy or the understanding to then make a judgment when you're then in that position of influence. As a police officer, when you have that choice whether to make an arrest or make a diversion or simply put somebody in the back of the car and take them home to their family. And having a deeper understanding of some of the cultural context and some of the community practices helps people take better decisions.
Desmond, you've spoken about how, in your reference to the Northern Territory, how entrenched some of these problems are. Would training make any difference when you're training police officers once they've joined or left the academy? Is that something that's going to be beneficial, or do we have to start somewhere else?
Well, I mean, I definitely, I would never say never, and I certainly think all of these things have a part to play. But obviously, as Julie points out, we are talking about endemic racism, both explicit and implicit, and we're talking, these are deep-seated problems. We're talking about consciousness raising. Myself, I think that art, and specifically contemporary Indigenous art, has an extraordinary role to play in helping the Australian community as a whole see its relationship to its past differently. I've just finished teaching a course on law and art at the ANU, and we spent a long time looking at colonial images of Aboriginal people, and then specifically modern Indigenous artists who are highly political and are creating some of the most forceful deconstructions of myths of Australian identity and myths of colonial law of anyone. Work by people like Gordon Bennett and Julie Goff and Fiona Foley and Judy Watson are extraordinarily powerful, and they have a way of not just sort of allowing people to sympathise or empathise, but actually sort of helping you reframe how you look at something. Sometimes when you look at some of these images which respond directly to the image and tradition and the myths that we have, you can't look at those myths again in the same way. It queers the field, right? It changes your relationship to what you thought was kind of the normal, conventional kind of history. And that's a kind of a process of reconstructing your relationship to your past and the stories you tell about that past that I think can actually transform people rather than just get them to follow a manual, right? Which is not a process of transformation.
How do we get that art that you speak of, whether it's film, whether it's music, whether it's visual art? How do we get people, the broader community, to interact with it and then to start changing those stories?
Right. I mean, as I said, I mean, that art is very much there. It was really the thing that really struck me when I did a study of, and I'm still doing a study of contemporary Indigenous art, was how much of it was about law and how much of it was about connecting images of colonial violence to contemporary images of violence, like deaths in custody, for example. The image of a man being hanged by an official is something that we see right across hundreds of years of colonial and then in Indigenous art. So that art is out there, and it's extremely articulate and it's transgressive in really kind of powerful ways. So I think we need to support that art. I think we need to fund it. But even things like the National Museum, for example, I think has done some really extraordinary exhibitions of trying to bring in different stories. The contemporary Captain Cook exhibition that's on at the museum right at the moment does a really clever job of juxtaposing European British stories of the first encounter with the Australian coastline with Indigenous stories about that same encounter, juxtaposing the image of Captain Cook as the great naval figure of the 18th century with Indigenous representations of the story of Possession Island and so forth. I think that the work in a place like the National Museum has been really important at trying to introduce different ways of looking at the same events, different ways of telling the same story, in ways that riff on and relate to our myths, but undercut them in really important ways. And it's that process of undercutting and deconstructing, I think, which is both transgressive and transformative in important ways.
Yeah, that's a really interesting point, Desmond. We have another question linking back to something we've discussed earlier. Would a treaty or series of treaties with different Aboriginal groups be better than constitutional recognition? Shane, I'm not sure if this is something, and I'm not particularly across the current situation in the ACT, but can you share your thoughts?
Yeah, look, I think that those, I don't claim to be the expert, and it'd be upon the community to decide whether a treaty or a constitutional recognition is better. I think they probably serve different purposes. I think both are important. I think here in the ACT, we could certainly, treaty is probably more of a localised matter, given the diversity of Indigenous nations across the country. But I think those large-scale, I don't want to call them symbolic because they're more important than that, but those things that send a really powerful message, I think are important. You know, we now have a Reconciliation Day public holiday here in the ACT. Now, some people have said, well, it's not going to make a difference. I think it does matter in the sense that it is a day where some of the stories actually get brought to the fore. But that cannot be all we do. We have to do the very practical things that really close the gap around housing, health services, getting people into university. But we have to do both, I think.
Julie, can I get your thoughts?
Oh, look, I just think, like at the end of the day, as the CEO of an Aboriginal community controlled health service that does pretty much everything here in the ACT, I think that, that's treaty recognition. How's that going to make a difference on the ground? What difference is that going to make? Really, people are still going to get locked up. Kids are still going to be removed. It's about having that effort and putting resources into making sure that we've got the resources to be able to do what we need to do to actually properly support these families, their kids, and to try and keep these fellas out of the justice system. Otherwise, we're never going to change anything. But, treaty, that's up to the traditional owners, even, constitutional recognition, all of those things. Some of this is so far removed from the ground that, at the end of the day, we just need to be resourced to get on and do what we do best, and that's to run an Aboriginal community controlled health service that looks at the social determinants of health, that goes into courts, does the court support, does the child protection meetings, goes into court to fight to get 3-day-old babies back. All of these things that people don't see is what we do pretty much on a daily basis. If it's not one family in crisis, it's another. Mental health is out of control. Historical trauma, identity issues, you name it. We're struggling with this every day. I'm an old Aboriginal Wiradjuri woman, and I found out a few months ago that my father could speak fluent Wiradjuri, and I didn't even know. And that was from an older Aboriginal man. It was Stan Grant's brother, Herb. And I was shocked because I said that my sister Beth and I were learning Wiradjuri from his sister Elaine. And he said, oh, did you know your father could speak Wiradjuri? He used to come to our house and speak with my dad, and they used to speak in language. But that's because they weren't allowed to speak it on the street. And he was protecting us. And, all they do, all that's done really is create another level of mistrust and identity.
Julie, that links us back to something that was mentioned earlier about the power of language and teaching an Indigenous language in schools. Is that something you would like to see happen to bring these issues to the fore and to sort of to I guess right the wrongs that have been done in the past and make this language more accessible more broadly? Is that something that you think would have any actual practical impact?
I think that our kids need to learn language, absolutely, and we should be teaching our little kids language from the day they were born, but we don't have that language to teach them. So we need to make sure that we've got preschools and we've got, that's the thing that I really want to do when we get our new building here at Woononga, is repurpose some of this building. And particularly for that purpose is to, when we've got high-risk clients that have got identity issues and all sorts of other issues, that we can look after their kids. But you've got storytellers here and people here too to empower these kids and to empower them families, Otherwise, we're going to have another lost generation, and who wants that?
We have another question here asking about the role that judges and magistrates play in all of this. What accountability do they have for their decision making, and how can that be challenged? Is that the problem here? I'll start with you, Shane.
Yeah, sure. Of course, under the Australian system, the judges are independent of the Parliament. We have that separation of powers issue. So the judges, I guess, are shaped by public opinion, the feedback that they get, but there is a duty on the Parliament to make sure that both the laws are good laws, and I again give my example of the anti-consorting laws earlier, but also that the judges have good options when it comes to where they direct people who come before them. That's about having good diversion options, about having services to send them to, so that jail is not the only option. In fact, jail should be absolutely the option of last resort. And we need a range of other services, whether it's a drug and alcohol service or a cultural service or the like. That's, I think, how we can better empower judges to make better decisions.
Desmond, I'd be curious to know, there's been a lot of talk in the last few months about anti-racism and anti-racist laws. Is that an issue here in Australia? And would you like to share your thoughts on, do we need more radical changes in our systems to address these issues that confront Indigenous Australians?
I mean, I think, you know, I'm not, certainly not opposed to things like hate speech laws and things like that. And I think the Race Discrimination Act is incredibly important in holding institutions to account. I think that corporate institutions need to be held to a stronger account than we're able to. And that question of corporate social responsibility is, I think, you know, an important part of this. So I think there's certainly a place for those kinds of legal structures. But I think, as I think we've all been saying in some ways, there is a limit to the legal ability to deal with underlying levels of social action. And I think that there are more powerful and far-reaching ways of dealing with that, and thinking that we can find some kind of legal silver bullet. I don't think that those kinds of legal silver bullets are not going to don't exist, right? I also think, you know, like we have to think about, as Shane is right to point out, the independence of the judiciary and so on. As I tried to mention earlier, one of the underlying, the deep-seated issues is a kind of a real reluctance in the Australian judiciary, particularly the higher reaches, to engage too strongly with questions of social context, or with broader kind of questions of the nature of justice and human rights in our society. And the court has been for 20 years, the High Court in particular, highly conservative. One of the most conservative, highest level courts in the world is the High Court of Australia. And I think that has put a brake on certain kinds of judicial responses to these issues that I'm disappointed that they've been so conservative about. I think one sort of lower level example of that is, as I understand it, we have in the ACT provisions that allow for community sentencing options, sentencing within communities. But I also know that studies that have been done at the ANU have showed that the judiciary is extremely reluctant to use those options, even when they're available to them.
Why?
And levels take up by the, well, because they don't think that they're really appropriate sentencing options, even though the evidence from our criminologists at the ANU is that they are very effective at engaging. They are, you know, powerful disciplinary mechanisms. They're not soft options, but they do allow a much better integration and a connection of offenders, Aboriginal or non-offenders, with services. So they have a real potential to break the logjam and the kind of, you know, the pathways to incarceration. But courts are very reluctant, and the ACT does not have a particularly good record. That comes down to the ways in which the judiciary themselves think about those sorts of things.
Can I just say that, you know, I've had a very good relationship with the magistrates and the judges here in the ACT, and they really do want to you know, make a difference and have a better understanding. But, you know, at the end of the day, it's the police that pick these fellas up. It's the police that bring them before the court. It's the DPP that go after them all the time, especially when they've got a criminal history. The magistrates and the judges can only do, they're bound by the law. So, you know, at the end of the day, the whole thing needs to be reviewed. But even with association, you know, we talk about association. Well, you know, the thing is, when you go to probation and parole and to all these other places like drug and alcohol or wherever, of course you're going to associate. How are you going to get away from these fellas? And then before you know it, they're off doing things together. So, you know, the whole system. But I think that it's more than just the magistrates and the judges. They really are trying to do things differently. But you've got the police and the DPP that just keep loading these fellas up. And, you know, they target them, they harass them. But when they should be picking them up is when they've breached their bail conditions. Don't just watch them, let them go, and then they're in there for years rather than, you know, picking them up and putting them in there so that we can try to address the issues.
Shane, can I get your response to that?
Yeah, no, I think Julie makes a really good point, and that's why we need to have better diversion options. You know, we have brought in, Desmond referenced things like what's called an intensive correction order in the ACT. It's designed to let people be sentenced to time in the community rather than time in jail. And built into that is things like swift and certain sanctions, so that if somebody does breach, they actually get put in jail straight away for just 3 days. So there's a direct correlation between the offending and the penalty, rather than this very disconnected sort of thing you get. And so I think these approaches are more creative. They're better just as options, but we need to make changes right through the system. The right laws, the police training, the police diversion opportunities. You know, I was looking at some criminal justice statistical profiles last year, because that's what you do in my job. And, you know, it had down a section where there was diversions for drug-related offences. And around 320 non-Indigenous people had been diverted during this period, and 2 Indigenous people.
Yeah.
And that tells you that in the system, where those decision points are being taken, the Indigenous people are not being sent for diversion. And you can speculate on the reasons for that, but it tells us we've got a problem.
We are approaching the end of this session, so I'd just like to get your final thoughts on the issues that we've discussed today. Julie, are you optimistic that we can change the pretty grim stats that we see year after year?
Well,
Improve the lives ultimately of Indigenous Australians?
I'm always optimistic, you know, and my priority is for my people, and it's for the people that access Woononga day in, day out, year in, year out, and that it's about having continuity. It's about that connection. It's about, there's so much disconnect between us and the rest of the mainstream services. We have a particular way of doing business, and we have our clients trust us, you know, otherwise they wouldn't come here, you know. And when you've got over 18,000 registered clients and you're providing almost 80,000 occasions of care a year, you know, we're obviously doing something right. So start to listen to us and to take on board what the community is saying, what the men and women in AMC are saying. They need help. They need assistance. They need us to be able to provide more than just a Band-Aid when they get out. You know, we're talking about historical trauma. It's like peeling an onion. There's layers and layers and layers, and it's not a quick fix. But, you know, the thing is, unless we actually do some intensive work with them, their kids are going to be the next generation of crims, you know, like, and nobody wants that.
Desmond, Shane, would you like to share any final comments?
Desmond?
You know, it's been a really interesting discussion, I think, because the people, you know, like we all have a very different starting point, I guess, and a very different skill set, very different knowledge set. Let's put it that way. So it's been really interesting to hear those different perspectives, and I can throw out something about its sentencing alternatives. I'm really pleased that Shane knew exactly the law I was talking about and could give it its proper name, because I'm not particularly good on that. And then, you know, from Julie, like so really interesting to hear that roots kind of connection that certainly people like me, you know, don't have to our detriment, I'm sure. But so I think, you know, I think about the Uluru Statement from the Heart, you know, and I think that was a really tremendous opportunity, again, an opportunity missed, because I think that when I read that document, they did a lot of work thinking about exactly what kind of story they wanted to tell, exactly how they wanted to position Indigenous and non-Indigenous people in relation to each other, in relation to a community, a group of people, children of the future, all of that. It was an extremely well-crafted and creatively crafted document. And what you saw from the government was an extremely thoughtless, knee-jerk reaction that immediately attempted to reappropriate the tropes and stories that we're familiar with. And that's why I think that things like myths and histories are incredibly important, because that the government response was more or less successful because people immediately channeled that kind of response. It was like, oh yeah, right, it's just that, it's just this. And in the process, the subtlety of that document and the effort to move the story along in important ways was lost. So how do you make it harder for politicians and thought leaders in the future to fall back on the same old tropes, the same old stories, the same old myths? And I think, again, that's where I think that we ought to be thinking a lot about the cultural world and the cultural resources that we have, and how better to support those, develop those, and disseminate those across the community.
That's a really interesting observation. Particularly, I thought your remark earlier about the power of art was a really profound one. Shane, would you like to make any final comments before we wrap up?
Yeah, sure, Norman. Going back to your question to Julie about does she have optimism? I do have optimism, but we're going to have to work very, very hard to bring about true reconciliation in Australia. And I think that does operate at two levels, to pick up a couple of the themes from today. Those big picture issues like recognition in the Constitution and Treaty are very important for sending deep cultural signals about who we are, what Australia really is, and what matters. About having a true understanding of the history of this country, about the frontier wars and the like. And we need to see those stories being told, not just on the ABC and SBS, but we need to see it on Channel 9 and Channel 10 and Channel 7 so that it breaks into the mainstream. I think that's the cultural resetting that we need to do. And then there's the very practical measures about better training for police, different laws, better alternatives to custody, those very practical matters around health services, the social determinants that continue to mean that Aboriginal people lead essentially poorer lives than many of their Australian counterparts, where they have a lower life expectancy and all those other things we know. We need to keep very focused on those practical matters as well.
Well, thank you everyone, panelists and anyone joining from home for attending today's session. I think it was, as Desmond mentioned, a broad discussion that sort of tapped into some practical but also some more creative ways of addressing some very serious issues that affect our Indigenous and Torres Strait Islander peoples. There will be another session at the end of September on racism in Australia, so stay tuned for future notifications on that from Blue Star Intercultural and the Australian Centre for Christianity and Culture. Thank you everyone for joining.
Thank you. Thanks, Noah.
Thank you.
Thanks a lot.
Thanks, everyone.